Good afternoon, everyone, and thanks for joining us for a Tax Practitioners Board webinar. My name's Julie Shaw, and I'm joining today from Ngunnawal Ngambri country. We respectfully acknowledge the traditional owners and custodians of country throughout Australia and their connections to land, waters, and community. We pay our respect to them, their cultures, and elders past, present, and emerging. Now, just to begin today's webinar, I have a couple of quick housekeeping messages. First of all, if you would like to access a copy of today's slides, you can visit our webinar resources hub, and you'll find that located at tpb.gov.au/webinar-hub. We'll also email you a copy of the slides following the webinar today, and we'll do that via the email address that you registered for today's session. And second of all, today's webinar does count towards your continuing professional education or CPE, and you can claim 1 hour for attending. Just in relation to claiming your CPE, we will issue an attendance certificate to those of you that are staying online for the presentation today. So let's have a look at what we'll be covering. In today's presentation, we'll be focusing on outsourcing and offshoring, including some examples of models. So in particular, we'll be unpacking factors you should consider when you're outsourcing and offshoring, which items of the Code of Professional Conduct are relevant. We'll also look at other things to consider, such as engagement letters, cloud computing, and the Privacy Act 1988. And then we'll look at consequences as well for inadequate outsourcing and offshoring arrangements. Then to finish up, we'll answer some of the questions that we received during the webinar. So if you do have a question, feel free to pop it into the chat box, and you'll find that located on the top right-hand side of your screen. And in that regard, we have Fiona from our policy and legislation team joining us today. She'll also be on hand to answer your questions as we go through the presentation. So before we begin, I'd like to introduce our speaker for today. We have TPB board member Deborah Anderson. Now, Deborah's a registered tax practitioner. She has extensive experience as a BAS and a tax agent. So welcome, Deborah. I'll hand over to you to get us started today.
Thank you, Julie, and it's really great to be here today. And a warm welcome to everybody. I can see we've got almost 2,000 of you online at the moment. Really appreciate you taking time out of your busy schedule, especially at tax time. I know it's already been quite hectic. Today, we do value your opinion, and we'd like to provide you with an opportunity to raise any questions that you may have with us. So please, Fiona is here to answer your questions. Hit us up with them. And now on to outsourcing and offshoring. So outsourcing and offshoring certain elements of the tax or BAS services are becoming more and more common. So given that, I think it's important to give you a better understanding of the implications that arise with these types of arrangements, and also to help you understand your obligations under the Code of Professional Conduct. The TPB website has a great practice note dedicated to this topic, and we've linked that in the hyperlink documents for today's webinar. It'll be sent out to you after the webinar, and it's a really great resource for you to refer to later.
Agreed. Thank you so much, Deborah, for the opening comments. I just, before we do dive into the presentation, I'd like to take a quick poll just to determine who we've got joining us today. So we'll launch that poll right now, and it will pop up on your screen in a moment. All we're asking you to do is to tell us in what capacity you are joining us today. So, for example, are you a tax agent, a BAS agent, or other professional? So just give everyone a few seconds to put through their responses, and then we're going to share the results, and we'll move into the presentation after that. Okay, I'm just going to keep it open for a couple more seconds just to give you a chance to put through a response if you'd like to. Okay, we'll close that one off. We'll share those results, so hopefully you'll be able to see those on your screen. But if not, I'll just let you know that we've got about 69.5% of people who are tax agents joining today, about 25% that are BAS agents, and about 5 to 6% who are other professionals.
Great, thank you. It's always nice to know who we're talking to, isn't it?
It is great to see, yep.
Yeah. Okay, so let's go on to some outsourcing. Outsourcing is where you, as an agent, enter into an agreement with a third party to provide a specific process or a function, a service, or an activity. It can involve transferring portions of the services you provide, or even transferring an entire operation to a third party rather than completing the work yourself. And this could be done for a variety of reasons. It could be to reduce costs, it could be to engage specialists, or it could also be because of overflow, too much work. So an example of outsourcing activities can also include things like contracting or engaging a third-party external IT provider to provide IT services for you. So that could be things like, hosting your data or, those types of things. It could be seeking an opinion or advice from a third party, and that could be from another registered practitioner or a legal practitioner. It could also be contracting with a third party domestically to undertake specific work, or it could be contracting with a third party, a foreign entity to undertake specific work. It could also be if you've got a service trust structure arrangement, and that's also considered where a third party trust is undertaking specific work for a registered tax practitioner. So you can see there's lots of different things that can fall under that umbrella. There are also various different outsourcing models, and they can be things like outsourcing of activities to subsidiaries or related entities. It could be directly hiring a third-party foreign entity, or it could be employing a third-party vendor who may be either in Australia or offshore and accessing systems remotely. Offshoring, on the other hand, is where you enter into an arrangement to transfer a process or a function or a service or an activity to a country other than Australia. And it's important to note here that offshoring does not necessarily involve the use of outsourcing. And an example of offshoring activities, including a registered practitioner, could be where you are transferring specific work, such as processing from your Australian office to an international office. And that is if you are the same entity. So no third-party involvement needs to be there. Or if you've moved an internal business unit from Australia to another country, again, no third-party involvement. Or whether you've engaged a third party in a foreign country to undertake the specific work, or engaged a overseas third party to host or to operate your computer infrastructure on behalf of a registered practitioner. It's also important to recognise that there are various arrangements that can be a mix of both outsourcing and offshoring. And some of the most common outsourcing and offshoring models include outsourced offshoring, which is the outsourcing of activities to a third party in a foreign country. It could be captive offshoring, which is where a firm sets up their own operations but in an offshore location. Or a joint venture model where an organisation forms a joint venture with an overseas service provider and transfers functions to that new entity. Now, Julie, you're going to do another poll for us now.
That is correct, yes. So now that we've got an understanding of what outsourcing and offshoring is, I thought it would be a good time to ask people if they actually have an arrangement in place. So this poll should launch now and hopefully it'll pop up on your screen. What we're asking you is essentially, do you outsource and or offshore any elements of your work? So the answers are yes, I do, no, I don't, or I'm thinking about it. So again, I'm just going to give you some time to put through your responses and then we'll come back and we'll share the results. Okay, we'll just keep it open for a little bit longer to give everyone a chance. Okay, I think we can close that one now. So we'll share those results, but I'll just let you know that we've got about 20% of people saying that yes, they do outsource or offshore, about 63% saying that they do not, and about 18% saying that they're thinking about it. So thank you everyone for putting those through. And Deborah, I'll hand back to you so that you can share your thoughts on that.
Yeah, that's a really interesting question, because when, I first read that poll question, I immediately thought about outsourcing or offshoring tax work. But of course, as we've already mentioned, it could be a range of things. It could be a virtual assistant. It could be hosting of data. So there's a whole range of different things in there. And I think realising that they all fall under that umbrella is really interesting. So anyway, I digress.
Thanks, Deborah. Now that we have a better understanding, we need to also, I guess, understand what the implications are that could arise from having these arrangements in place. So could you tell us what items of the code may be relevant for practitioners considering these sorts of arrangements?
Oh, of course. But first, I want to make it clear that while the tax practitioner environment is changing and evolving every day, the obligations and the responsibilities of tax practitioners remain the same. So our role at the TPB in regulating tax practitioners in the digital age also remains consistent with our ongoing focus on consumer protection. So we protect consumers of taxation services by regulating tax and BAS agents, thereby strengthening the integrity of the tax profession. So with that in mind, it's important that we all remember that from the moment you register with the TPB, you are required to comply with your ongoing obligations under the Code of Professional Conduct. So ultimately, it is your responsibility to exercise appropriate due diligence when outsourcing work. So you need to ensure that there is appropriate disclosure is provided, that their services are provided to a competent standard, and that there's adequate supervision and control arrangements in place. So let's now take a high-level look at the Code of Professional Conduct before I go into some of the specific code items that relate to outsourcing and offshoring. As I'm sure most of you online are aware, the Code of Professional Conduct sets out the professional and the ethical standards required of all tax and BAS agents. Included in the obligations, included in that are the obligations that you have to your clients, to the TPB, and in relation to your own conduct. So the code has 14 items currently, that are grouped under 5 key principles. And the principles are honesty and integrity, independence, confidentiality, competence, and then the catch-all being other responsibilities. For the purpose of today's webinar, I'll be focusing on several items under the Code of Professional Conduct that are relevant to outsourcing and offshoring, and how they apply to the way you carry out your role as a registered tax practitioner. So under Code Item 6, which relates to confidentiality of client information, I'll look at when you can disclose information relating to a client's affairs to third parties, and how this specifically relates to outsourcing and offshoring work. Under Code Item 7, I'll look at how tax agent services you provide must be done competently. And sorry, I should have said tax and BAS agent services you provide must be done competently. And under Code Items 9 and 10, these relate to reasonable care. So I'll have a look at how you need to take reasonable care to ascertain your client's state of affairs and ensure that you correctly apply taxation laws. And under Code Item 13, we'll have a look at how you must maintain professional indemnity insurance that meets the TPB requirements. So as mentioned, tax and BAS agents, or all tax practitioners, have an obligation under the Code of Professional Conduct to ensure the confidentiality of their clients' information. You must also ensure that clients are aware of any offshoring arrangements and that they have given their permission for third parties to have access to their information. To avoid a potential breach of the Code of Professional Conduct, you must not disclose any information relating to a client's affairs to a third party without the client's permission unless there is a legal duty to do so. And to clarify, information refers to the acquiring or the deriving of knowledge and includes, but is not limited to, capturing information known about a client. Importantly, the information does not have to belong to the client or have even been directly provided by the client. It's only necessary that the information relates to the affairs of a client. A third party is any entity other than you and your client. So a third party could include another registered agent that you outsource a component of your services to. A third party could be a legal practitioner. It could be an overseas or offshore entity. It could be an offsite data storage system. It could be an overseas party that shares the same brand or name that you have in Australia, but is a separate legal entity. It could be a wholly owned subsidiary. It could be a service trust. It could be a separate entity, partly controlled by an outsourcer that, whether they're based in Australia or overseas. And it can also be an unrelated party, such as a subcontractor, or if you've got labour hire agreements in place. So when disclosing a client's information to a third party, you should firstly clearly inform the client about the information that you will be disclosing. You need to advise to whom and where the disclosure will be made, and you need to obtain the client's written permission unless you have a legal duty to disclose the information. And that's a really important point. You need to have their written permission. And so for those disclosures that are for things like offshoring or outsourcing, we recommend the use of an engagement letter between you and your client, and that will set out the terms and conditions of the engagement. So that could also include a statement about whether you intend to pass the client's information to a third party and how you will get the informed consent to do that. And I'll talk about engagement letters a little later in the webinar. There are a number of other controls that could be used to assist in maintaining and protecting the confidentiality, integrity, and the availability of data to ensure that information is not disclosed beyond the scope of the client's consent, such as having an appropriate confidentiality agreement between the registered practitioner and the outsourced provider, or other appropriate protocols such as secure and encrypted systems, security credentials and access controls, making sure that unauthorised persons don't have access to data, using things like audit trails and exception reporting, and of course the appropriate segregation of duties. Under Code Item 7, tax practitioners must ensure that a tax agent service they provide or that is provided on their behalf is provided competently. And that includes services that are either outsourced or provided offshore. If you outsource part or all of your tax or BAS agent services to an unregistered third party, you need to ensure that the work performed by that third party is under your supervision and control or under the supervision and control of a registered tax practitioner. So you are ultimately responsible for the quality of the work of the unregistered third party, including ensuring that there are appropriate supervisory arrangements. So when you're considering an outsourced or an offshore arrangement, be careful to consider the extent that this may impact on your ability to supervise the work. You should ensure that any services provided to clients in Australia from a location outside of Australia are provided competently, just like it needs to occur if it was inside Australia. It's also important to recognise that while supervisory arrangements may be an important factor in ensuring services are provided to a competent standard, it actually won't ensure competency, and you need to make sure that there are adequate supervisory and review arrangements in place. So that includes having a sufficient number of registered individuals, being registered tax or BAS agents, that are supervising or reviewing the work being carried out. Secondly, that there is the internal procedures that are used satisfy the supervisory and control requirements, and may have activities such as training for offshore staff in Australian tax, registered tax practitioners or other experts being on site overseas to oversee it, the rotation of overseas staff to gain experience in all the different facets of Australian tax law, and also appropriate quality assurance and review systems. Thirdly, that registered tax practitioners are involved so that the work being completed overseas is considered competent for Australian tax law purposes. Fourthly, that the registered tax practitioners are meeting their requirements for maintaining knowledge and skills relevant to the services they're providing. And lastly, that the registered tax practitioners are maintaining competence by continuing awareness, understanding, and up-to-date knowledge of relevant technical, legal, and business developments. Now, on to code items 9 and 10, which cover taking reasonable care. Code item 9 requires that a registered tax practitioner needs to take reasonable care in ascertaining a client's state of affairs to the extent that ascertaining the state of those affairs is relevant to a statement they are making or a thing that they are doing on behalf of the client. Code item 10 says registered tax practitioners must take reasonable care to ensure that taxation services are applied, taxation laws are applied correctly to the circumstances in relation to which they are providing advice to a client. So when that comes to outsourcing or offshoring, unfortunately, there's no set formula for determining what it means to take reasonable care. You need to take into account a range of factors to ensure you comply with your reasonable care obligations under the Code of Professional Conduct. At a high level, you should consider the nature or the scope of the services that are being provided, the terms of engagement between the registered practitioner and the outsourced provider or the offshore entity, the terms of engagement between the registered practitioner and the client, including whether the client or another entity checks or reviews the work before relying on it, the skills, the experience, the qualifications, and the abilities of the outsourced or the offshore provider, the degree of supervision and oversight that the registered practitioner exercises over the provider's provision of tax or BAS agent services, the client's circumstances, including the client's level of sophistication, what is their education standard or the level of tax knowledge or experience in the area which is the subject of the advice, as well as the nature of any pre-existing relationship between the registered practitioner and the client. The standard generally requires that a registered tax practitioner acts in a way consistent with how a competent and reasonable person possessing the knowledge, skills, qualifications, and the experience of a registered tax practitioner would act in the circumstances. So the board expects, due to the nature of the use or the engagement of an outsourced or offshore provider, that registered practitioners will be required to take additional steps and measures to those that they would ordinarily need to take in their practice. This will ensure that the applicable technical and professional standards are met and that a client receives competent professional services. From the TPB's perspective, we can appreciate that any relevant changes made by an agent for the purpose of complying with the above requirements can take time to implement. And where there is modification or where modification is required, we will take a pragmatic approach in assessing whether you implemented the adequate procedures and policies in relation to the outsourcing or the offshoring arrangements. And if you have inadequate procedures or policies in relation to your outsourcing or offshoring arrangements, we may also find that you have breached the Code of Professional Conduct and may impose one or more administrative sanctions. Lastly, Code Item 13 requires that registered tax and BAS agents or tax practitioners must maintain professional indemnity insurance that meets the board's requirements. So PI insurance is a consumer protection mechanism designed to compensate your clients in the event that they suffer a loss due to an act, error, or omission of a tax agent services that you've provided. The objective of our PI insurance requirements is to ensure that you have adequate PI insurance to cover the type of BAS or tax services that you are providing. And features include things like the scope of cover, the amount of cover, the people, the persons who are covered, what the exclusions are, and also the insurance provider. So if you outsource or offshore services, the number one thing you should be doing there is reviewing your PI insurance policy to make sure that you have appropriate coverage for your services. And I'm going to hand over to Julie for another poll.
Thanks, Deborah. Give you a little breath. So the poll that we've got this time is a multiple choice question, and it's based on a scenario that you may encounter. So we'll just launch the poll. And once again, it should pop up on your screen. So if you could just take a moment to select the correct response from the list. So the scenario goes as follows. We have a registered tax agent. They're minimising their operating costs by entering into an agreement with a bookkeeping and data processing firm overseas. The bookkeeping firm will perform the bookkeeping and data processing work for the registered tax agent. To send the information overseas, what does the registered tax agent need to do? So we've got a few options here. First of all, do they need to disclose the arrangement to their client? Should they obtain the client's explicit permission to disclose the information to the overseas firm via an engagement letter or other written agreement? Or should they do all of the above? So please just take a moment to answer that question, and we'll come back and share the results with you all in just a second. Okay, it looks like we've got about 40% of people responding so far, so I will keep it open for a few more seconds. Okay, we might close that one off and we'll share the results. They'll pop up on your screen in a second. And Deborah, I'll just let you know that we've got about 2% saying that they should be disclosing the arrangement to their client. We've got about 88% saying that they should do all of the above, and about 9% saying that they need to obtain the client's explicit permission to disclose the information to the overseas firm via the engagement letter. So I'll just hand back to you now so that you can discuss the results with everyone.
Yeah, thank you, Julie. And those 88% that said all of the above are correct. So in this case, number one, you need to disclose the arrangement to your client. And number two, really importantly, you need to also obtain the client's explicit permission. So it needs to be in writing, if you're going to be entering into these. So well done to the 88% of people. So, Julie, I might just move on to engagement letters. Is that okay?
That sounds great. Thank you, Deborah.
Great. I mentioned engagement letters earlier, and I'd like to look at them in a little bit more detail now. So firstly, for clarity, letters of engagement are not compulsory for the TPB requirements. However, we do highly recommend that you use them. They can assist in avoiding all sorts of disputes, particularly a really common one that we get is disputes over fees, which, by the way, the TPB can't look into. But if there had been a letter of engagement, usually that is not an issue. So letter of engagements can assist in avoiding disputes over fees, but they can also assist in disputes about the scope of work that was to be completed as well. They're a really important business tool that can help you set clear expectations with your clients about what they can expect from you. And importantly, you can also set what you expect from your clients as well. So an engagement letter is just the starting point in an ongoing relationship and communication between you and your client. It covers things like what is to be done, who will do it, how will it be done, when and where the work will be done, how much the work may cost, and if necessary, this is where you can also get their permission to offshore or outsource to third parties. Now, we often get lots of requests for a template of an engagement letter. We don't have a template because the sheer diversity in tax and BAS agent practices to cover everybody's scenarios is quite literally impossible. So we do consider it's incredibly important for all registered tax and BAS agents to use their professional judgment in considering the matters to address in your own letters of engagement, having regard to your practice and also the engagement arrangements that you have with each and every client. Engagement letters can include your expectations of the client. So, for example, that it's the client's responsibility to make sure all of the relevant information is available to you, the practitioner, in a complete and timely manner. Good luck. And also for the client to advise you of changes in any matter that is relevant to the services that you're providing. It can also include an explanation as to the extent of that the services can be relied upon, and a really good one here is loans. You might want to say, cannot be relied on for the sake of a bank loan or something like that. The confidential nature of the communications, and that you will not disclose information relating to the client's affairs to any third party without the client's permission. Again, in brackets, unless you have a legal duty to do so. Can also go through your duty under the Tax Agent Services Act to act lawfully in the best interests of your client, and also to act honestly and with integrity. And that you have adequate arrangements for the management of things like conflicts of interest, that you have what the client's rights and obligations are under taxation law. Also things like if you receive funds on behalf of your client, refunds, for example, how will you deal with the tax refund, and does the client agree to things like fees being deducted from your refund? And also just letting them know how you will deal with those funds. So, putting them in a trust, those types of things. It's also important to include the name and the registration number of the tax practitioner that the client is appointing to perform the services, and that gives certainty to the client that the services will be performed by a person that is legally entitled to do so and is regulated under the TASA. And I know we've often hear that, we need to educate particularly small business and also individuals about using registered agents. And one way that we can all educate registered agents is by actually putting this information in so that people become aware that it is a requirement to be registered. Now I'm going to turn my attention to cloud computing. So to be clear, using a cloud provider does not necessarily mean you are offshoring or outsourcing work. However, if you are undertaking offshoring and outsourcing, it's very likely that you will be doing that through the provision of cloud computing. So that's why the two issues often go hand in hand. The most important thing to understand before you enter into any kind of cloud agreement with a service provider is who can access yours and your client's data. You should also find out from your service provider what happens when an agreement ends. So, for example, is the data returned to you, or will you still have access to the data held in the cloud after the agreement finishes? The other thing to understand about cloud computing is cloud services are generally operated from facilities located in premises remote from the places where the data was created. And all information stored in a cloud service is physically located somewhere in one or more data centers and could be spread across the world. So understanding where your data is located can help you to assess the risks and the benefits of using that cloud provider. You should also find out how often your data is backed up, as well as what happens in the event of a data breach. And Julie, back to you for another poll.
Thank you so much, Deborah. This is the last poll for today, and it is another multiple choice question based on a scenario that you may encounter. So this scenario goes as follows. We have Jenny, who is a registered tax agent, and she runs her own practice. She outsources some simple work to an offshore provider who's located in Indonesia. She uses cloud technology to send data to the third party. Jenny is not tech savvy, and she doesn't quite understand how often...
Can't hear you properly, Julie. Sorry.
Oh, sorry, everyone. Is that better?
Yes, much better.
Okay, let me start that scenario again. So Jenny's a registered tax agent and she runs her own practice. She outsources some of the simple work to an offshore provider who is located in Indonesia. She uses cloud technology to send data to the third party, and she is also not very tech savvy and doesn't quite understand how often this data is backed up or what would happen if the data was lost. However, Jenny has gained her client's permission to disclose the information to the third-party provider by way of a signed engagement letter. So Jenny has detailed procedures in place to ensure all work conducted by the third party is done correctly, and she regularly conducts random audits of their work. So in this situation, do you think Jenny has met her obligations under the code? And when you're thinking about that, specifically consider code item 6, which is confidentiality, and code item 7, which is competence. So we've got the 3 options to choose from in this poll, and they are yes, no, and unsure. So just take a moment to put through your responses, and as always, we will come back and share the results and discuss what the correct answer is for everyone after we've concluded. Okay, I'm just going to keep it open for a little bit longer, a couple more seconds, just to give everyone a last chance. So once again, the options are yes, no, or unsure. Okay, we might close that one off. And we're going to share those results. They should come up on your screen any moment now. But if you can't see them, I'll just let you know we've got about 36% of people have said yes, About 47 have said no, and 17% of you are unsure. So thank you everyone for your participation. Deborah, back to you.
Great. So if we look at code item 6 first, Jenny has met her obligations because she got the permission from her client to disclose their information to a third party. So big tick for Jenny on that one. However, code item 7, she does have the procedures in place and she does random audits on the third party providers. So that's all really positive on examples of how she's doing it. Unfortunately, I think the area that she falls down here is that in her competence is not really understanding the arrangements with the providers. So in that case, not actually, it's the lack of understanding and lack of asking questions that she's probably falling short for on code item 7. So, ask more questions, Jenny. Now I'll move on to the Privacy Act 1988. And in addition to the obligations under the Code of Professional Conduct, all registered tax and BAS agents need to be aware that the Privacy Act 1988 sets out a number of Australian privacy principles, and I'll call them APPs, which govern the use of and the storage and disclosure of personal information. So some of these APPs may have a direct impact on the requirement to obtain consent from clients. And the Privacy Act is an Australian law which regulates the handling of personal information about individuals. The Privacy Act is administered by the Office of the Australian Information Commissioner, and under the Privacy Act, an APP entity must protect the personal information that they hold from misuse, interference, loss, unauthorised access, modification or disclosure. APP entities also need to take reasonable steps to destroy or to de-identify personal information when it's no longer needed for any purpose permitted under the Privacy Act. So you should keep this information in mind when you are handling clients' personal information, and registered practitioners should seek their own advice about whether the provisions of the Privacy Act relate to them.
Great, thanks, Deborah. Could you take us through the administrative sanctions that the TPB can impose if it's found that a tax practitioner has inadequate arrangements in place for outsourcing and offshoring?
Sure. If the TPB finds that a tax practitioner has failed to comply with the Tax Agent Services Act, we can impose one or more administrative sanctions. The sanctions available to us include a written caution and an order. So an order could require the practitioner to do certain things. So it could be, we order you to complete a course of education or of training, and that might be in, say, work-related expenses, for example. We could also order that you only provide certain services, or we could also order that you provide services only under the supervision of another tax or BAS agent. In the more serious cases, we also have the suspension and termination of registration sanctions available to us. The severity of a sanction depends on the nature and the extent of the breach and the individual circumstances in each and every case. And of course, if you disagree with the board's findings, practitioners have the right of review with the Administrative Appeals Tribunal, and the AAT can provide an independent review of our decisions.
Fantastic. Thanks, Deborah. I think we've got some time now to have a look at some of the questions that we've been receiving. So I might put some of those to you, and we can share them with everyone in the audience. So the first question that I have for you is, how can a tax practitioner supervise work that's outsourced to an overseas company?
Yeah, look, it's a tricky one because there's no standard process to determine whether your supervisory arrangements are adequate, but you can go through some of the things to check. And again, I mentioned earlier, we've got a really good practice note on this. Julie, will that be attached to the email that we send? Or
It sure will. Yeah, we'll include that.
Yep. So things to consider could be the provision of appropriate training to the staff, and also ongoing training. So it's not a set and forget. It can also require periodic or spot checking of material that has been prepared by staff, and also the supervision of, some of the other work that's being done by office staff. Ensuring that the staff engaged to provide the services possess a adequate level of education and an understanding of the relevant tax legislation concepts to undertake the tasks which you've made them responsible for. And of course, the more complex returns, that requirement is a lot more onerous rather than the simpler returns and concepts. There's also things to think about, like the level and the depth of personal physical oversight that's taken over the provision of those services. So obviously being close to somebody, sitting next to them at the desk, it's a lot easier to go, hey, what about this, and ask questions than it is if the person is overseas, and also potentially in a different time zone as well. So, that's something that you need to take into consideration, and making sure that you've got the processes in place that staff can ask questions, that they are encouraged to ask questions, and they get answered. So there also needs to be, depending on the level of education and experience by the staff member, they need to look at things like, what's the level of supervision? So merely just checking a document and go, oh, that's reasonable, yep, I'm happy with that, it is not actually demonstrating a sufficient degree of supervision and control. We would actually expect a lot more checks and balances to be done. So I hope that answers some of the questions. But again, the practice note is really extensive. So have a look at that.
Thanks, Deborah. I think there's a lot of good things to consider there. But as you say, the practice note is a really great resource, and we will share that with everyone as well. So the next question I have for you is in relation to the cloud, and it's one that we do get a number of times. And really, they're just asking, is the cloud safe?
Love this question. Yes. Look, cloud computing is safe. However, its degree of safety, I guess, is highly dependent on the security controls and the infrastructure that's in place. So firstly, review the terms and conditions of your cloud provider. Is the provider allowed to change the terms and of the agreement without telling you? Where is it stored? How is it managed? What jurisdiction does it fall under? How is the information being transferred? Is it encrypted? Is it unencrypted? Is it zero knowledge? What processes does the provider have in place for a backup? Or what happens when, do they archive information if you need to go back? Making sure you've got things like adequate security controls. And I think we did a webinar, gosh, they all seem to be so recent, but maybe a couple of weeks ago, on keeping it secure, which is up on our YouTube site at the moment, which is all about, the security controls, having them in place. So again, passwords, multi-factor authentication, encryption, backups, all of those types of things, but also, speak to them about what happens when the service is being disrupted. And I know many of you, we've had that over the last few days with tax season at the moment. So, what happens in those cases? How can you, keep working if that's a requirement? So, all of those things are things to consider. And also, importantly, what happens when you decide not to use that service anymore? what happens, is there the return of data? Do you still have continued access to data? Do you need to pay for data or do you need to still pay to be able to have access? How is that data deleted off servers? Is that secure? So again, there's a lot of things to take into consideration. And, we've come a long way in the cloud computing space over the last, 10, 15, 20 years. And a lot of that information is now available on our cloud computing providers' websites.
Thank you so much for that, Deborah. Another good resource is the Australian Cyber Security Centre. They've got some great information there about cloud computing. And I'll give a little hint of a webinar that we've got coming up soon is going to be on cyber security, where we've got a member from the Cyber Security Centre coming on to talk to us. So I think that's a really good one to look out for everyone. Yeah, it'll be a really good session. I'm really excited to have them coming on board with us. So that'll be advertised fairly soon. Deborah, the next question that I've got here is talking about in the webinar you discussed not disclosing client information to a third party. They're just seeking a little bit more clarification here, and they've asked, does that mean that they can't disclose information to another registered tax practitioner that they work with that is not part of their practice?
Yeah, that's right. Unless you have your client's permission, you cannot disclose their information to a third party. So as we discussed earlier, a third party means any entity other than the client and yourself. So, you as the registered practitioner. So, if you're engaging or outsourcing work to another registered practitioner or a legal practitioner or a contractor, that's disclosure. If you are discussing it with their spouse or their child, anyone related to that client, that is disclosure. You need permission to do that. And even if you are dealing with somebody within the same structure, unless the clients are all defined in your engagement letter as the whole structure, it's disclosure. And again, even if you are having offsite data storage systems, so, let's think Dropbox, all those types of cloud storage, that is disclosure. So yes, anybody other than you and the client.
Thanks, Deborah. That's really good to know. I think that's an important point that some people may miss. The next question I've got, I think you kind of touched on this already in the presentation, but as I think you mentioned, we do get lots of questions around this, and it's, can you provide a template for engagement letter?
Yeah, look, it is probably one of our most asked questions, other than where is Deborah's dog today? And we don't have a template for a letter of engagement. What we do have is a sensational practice note on letters of engagement, and really with letters of engagement, the sky's the limit of what you can include in there. But we do very clearly go through the things that we highly recommend that you include. Who will do it? What will be done? What won't be done? How will it be done? How much might it cost? If you are, outsourcing, offshoring. And we've also got a couple of really good resources. Julie, I don't know if it's possible to add these to the link, but there are really good resources for what your client's duty is to a tax agent and what your client's duties are to a BAS agent, which are good to attach to a letter of engagement as well, because, they're official. And that shows actually both ways, what your obligations are and what their obligations are. But I think it is really important for clients to understand they have obligations to you as an agent as well. Highly recommend that you put your name, registration number, and a shameless plug for your TPB registration symbol. As I said earlier, dual purpose educates people that you should be registered, but it also helps them recognise that you are registered and gives you that stamp of approval. And they can also then go onto the TPB register and look that up if they want to. That gives them certainty as well. If you are looking for a template on engagement letters, have a look with your professional body. Most of your professional bodies do provide that, or many different types of templates actually, because the template will change depending on the type of client, the sophistication of the client, the complexity of the client, whether it's an individual client, a company client, a trust client, a SMSF client. So as you can see, there are so many templates, which is why we just, can't keep all of that up to date. But have a look with your professional association. And if you are not a member of a professional association, Google it. A lot of the professional bodies do offer them free. They're not behind a paywall, so you can get them. And of course, make sure you modify them so they are suitable for your practice and also for your client.
Thanks, Deborah. That's a really good tip, actually. Thank you. I've got another question here, and it's from a registered tax agent, and they've said that they've outsourced clients' bookkeeping work to other bookkeepers who are located in Australia. So the arrangement is mentioned in the engagement letter that they have with the client, and they're just curious, is there anything else that they have to do in terms of the Code of Professional Conduct?
Yeah, look, it's great. I'm glad that the arrangement is in your engagement letter. However, you do also have an obligation to ensure that any tax or BAS agent service provided on your behalf is provided competently. So if any of those bookkeepers are not registered practitioners, you do need to ensure that the work that is performed by the bookkeeper is under your supervision, it's under your control, or it's under the supervision and control of another registered tax practitioner.
Thank you. Next question I've got here is about cybersecurity. This one is, if you use an offshore office, is there a bigger risk of scam or a cyber attack?
Look, I think the reality here is that everybody or anybody can become the victim of a cyber attack or a scam. And, we've all got a responsibility to, be aware, be careful, and train all of our staff. So, look, there are the processes in other countries, are not necessarily bound by Australian privacy law. So I think that's something you need to take into consideration. And also just remembering that you're not able to supervise as closely if they are overseas. So, making sure that you give them adequate training on scams, on cybersecurity, multi-factor authentication, making sure all of those fundamentals are in place. Yeah, look, I'm not quite sure, to be honest, if offshore is a bigger risk, but the reality is the minute that you are online, you are at risk, and being a tax or a BAS agent makes you a slightly bigger target because of the rich information that you have access to and that clients send you, often unsolicited, straight to your email. So, please, we talk about cybersecurity all the time. You just can't be too safe.
That's very true. Thanks, Deborah. I think that's all the time we've got now for questions. So just to finish up, I do want to give some information on how everyone can stay in touch with us. So I'd like to encourage you to follow us on LinkedIn, Facebook and Twitter, and we'll keep you up to date there with all the latest information that we have available. We also have our monthly newsletter, TPB e-news, which you can subscribe to, and you can go to tpb.gov.au/newsroom to subscribe there. If you're interested in attending more of our webinars, you can go to tpb.gov.au/webinars. You can also subscribe to our YouTube channel, and as I'm sure you know, we do record our webinars and we have a comprehensive library available on YouTube. And when you view those recordings, you can also still claim your CPE, which is really good to know as well. Now, just to finish up, I want to say a huge thank you to Deborah for all the information that she's provided us with today. And thank you to Fiona for assisting with the questions as well. It was great to have you on board with us too. Finally, just be launching an exit survey, which will pop up in your browser once you leave the webinar. It would be really great if you could complete that. It's very quick, but just gives us some information on what you like to hear about, and all, you're also welcome to put any feedback in there on how we can improve the sessions to make them more valuable to you. So once again, I just want to say thanks everyone for joining us today, and we do hope that you enjoy the rest of your day. Thank you very much.